But I view that Nuremberg back to the U.S., back to Chautauqua County, as a sort of rising path. And I really feel like I'm at the peak now. It's really great to be back here with each of you. I want to put this building on first, because that is the topic of my talk, the Supreme Court. It doesn't actually say Keystone on the front of the court, or Lenshev. We'll clean that up in a second. If you're seated a little bit back, you might want to move up, because I do have a large number of visual images that I will use during this talk. I'm going to talk about 5 things: the White House, the life of Jackson, his path to the Supreme Court and his service there before Nuremberg, court-related issues, U.S. Supreme Court-related issues during Jackson's time away at Nuremberg, and finally Jackson's 8 years on the Supreme Court post-Nuremberg. So why am I showing the Supreme Court if I'm starting with the White House? Well, and why not this Nuremberg courthouse? Well, it's a Jackson building that, in a sense, is the pathway to the Supreme Court. This is Jackson with the Vice President, John Nance Garner. You know his famous line about a bucket of warm liquid. That's his view of the vice presidency. It's quoted in different ways, but he didn't say spit. And Jackson's White House-ness included, of course, a lot of time at that desk with people like that fellow, Harry Truman, who appointed him to the Nuremberg job. But none of this is really why I want to talk about the White House. This is why I want to talk about the White House. This fellow, a judge of the D.C. Circuit Court of Appeals, was called to the White House in the summer of 2005 for an interview with President Bush and a small group of insiders who had a Supreme Court vacancy somewhat unexpectedly when Justice Sandra Day O'Connor announced her plans to retire. And so Judge John Roberts, then teaching a summer course in England, jumped on a plane and flew back, and with very little sleep went into the Oval Office for this vetting session. And he was asked a whole bunch of questions, and in his extremely brilliant and very artful way, which of course has become familiar to all of us subsequently, I think he did a very good job by all accounts. One interesting question during that interview, we know this from various accounts, including Karl Rove's memoir, was which Supreme Court justice in our history do you most admire, emulate, think of yourself as in the form of? And John Roberts' answer was Robert H. Jackson. Now, the way Karl Rove writes about it is that he was the only non-lawyer in the room. He knew of Jackson and Nuremberg, but he didn't really have much of a sense that there was a sort of jurisprudence behind it. It was a very popular, satisfactory answer. Roberts was nominated. Shortly thereafter, when Chief Justice Rehnquist succumbed to his thyroid cancer, that nomination was withdrawn, and instead he was nominated to be the Chief Justice of the United States. And of course, he is. 7 years later, and of course he is, cover of Time magazine, the author of an opinion, by some accounts the court's opinion, but at least the decisive vote opinion in the healthcare case that the court decided at the end of June. Now, John Roberts is a window into this issue of Robert Jackson on the Supreme Court, and particularly Jackson on the court after Nuremberg. Jackson's jurisprudence, if you will, is a very hard thing to summarize. It is a very idiosyncratic, individualistic, non-dogmatic, non-theoretical, case-at-a-time kind of judging. Which means, frankly, that in his life, his 13 years, 12 actually at the Supreme Court doing judicial work, Jackson was a hard vote to predict. Jackson did have positions and did have people who he voted with more than others and so forth, but he was an independent justice. He was a justice in play. He was a justice who looked at the matter at hand and decided, sometimes to the surprise of the appointing executive, the litigants, etc., the case at hand. And I think, in a way, John Roberts in 2012 has very dramatically, very publicly, very controversially lived up to that straightforward answer he gave to President Bush, Karl Rove, and others in the Oval Office in 2005. I want to be like Robert Jackson. And I must say, in summary of the work I do in my life, that's not a bad thing to wish to be. Now, Jackson's life, very familiar to many of you, is a topic that I wish to churn through. That's him leaving Nuremberg with a smile on his face in 1946. We'll come back to that moment. But it begins, of course, much, much earlier. A few more Nuremberg images before we get to the life. Settlers cleared a valley, built a farm, etc., and a form of late 19th century prosperity. And from there, his father, not cut out for the farming life, moved across the New York state line to Frewsburg, opened the Hotel Jackson, which you see here. It didn't stand long, it burned to the ground. He built houses. You see here one that he built, and here in the background the other that he occupied, and that's Jackson's mother, sister, father, youngest sister, and one of her buddies, I think taken at a time after Jackson had grown and left the home. From Frewsburg, oh, there's one charming little Frewsburg image. That's Robert Jackson behind his boyhood home. What's he doing? He's pulling weeds. That might be another good way to think of his jurisprudence. From Frewsburg, Jackson graduates and moves to Jamestown. He attends the Jamestown High School. He becomes a law apprentice. He attends the Albany Law School for a year. He again is back in Jamestown as a law apprentice. At age 21, he becomes a lawyer. After a few years in Jamestown, largely as a solo practitioner, he's recruited to Buffalo. He practices in the Ellicott Square building, the largest office building on the earth, for about 2 years. Big city, big network, rising practice star. By the way, the new federal courthouse in Buffalo, which is a majestic facility, is in the process of being named the Robert H. Jackson United States Courthouse as a tribute to that life, but directly connecting to this part of his heritage. And then Jackson, becoming a little bit fuller of face and bigger of reputation, decides that the Jamestown perch is really the place from which he can rise highest and fastest. And so from Buffalo, he moves back to Jamestown. He and his wife begin to have a family. He begins to grow his law firm. Eventually, it becomes Jamestown's biggest law firm, 5 lawyers. And he becomes a regular litigant before the New York Court of Appeals, a criminal and civil trial and appellate litigator, a corporate counselor, the Corporation Counsel Municipal Attorney of Jamestown, a member of the regional bars, which rise and connect him to the American Bar Association. He becomes the head of the American Bar Association House of Delegates by the early 1930s. He becomes a member of the American Law Institute in 1930, etc., etc. This is a high-rising legal star. That's the kind of house that you build in the 20s before the Depression has crashed on us, when you are a wealthy Jamestown lawyer. And that beautiful home still stands on Fairmount Avenue, now known as the Lakewood Road, or then known as Lakewood Road, now known as Fairmount Avenue. That's a picture of Jackson at his boat on Chautauqua Lake. It's a good, comfortable, prosperous, diverse life. Big corporate counsels, clients, and big-time criminal cases, and everything in between is what he's doing, and he's very happy. But Washington calls. This is a series of locations from that house, which he never returns to live in Jamestown. This is the Wardman Park on Connecticut Avenue. I think many of you know of it, right above Rock Creek Park, where the Jacksons lived in an apartment for much of the middle and late 1930s. That's the Jacksons on their farm in Maryland, where they lived for a year. That's Hickory Hill in McLean, Virginia, which they bought in 1941, and where Jackson lived for the rest of his life after he got a job for life that meant he wasn't going to be leaving Washington. But this is the political side, and now we're back in the White House. This handshake is a friendship, a close, intimate advisor friendship by this point. It began way back in 1911, when FDR was known as Frank Roosevelt, when he was a freshman state senator, when Robert Jackson was an 18-year-old law apprentice, and each path rose, and obviously Roosevelt's top path, appointing Jackson, is his path to Washington. This is Jackson on a presidential fishing trip. I have loosened my tie and taken off my jacket, and the lake is here, and some of you may fish. Fishing today, even for the most nattily attired fisherman or fisherwoman, doesn't begin to match the way they dressed on a fishing trip in 1935. That's off the Florida Keys, Jackson, Harold Ickes, Jesse Jones, and the President of the United States. By the way, doesn't he look jaunty and relaxed standing there so casually? You'd never know that he couldn't do it without the braces that were locked below his waist and the pole that he's clutching with his right hand, a little bit off camera. That's Jackson on the cover of Newsweek in 1935 with Jim Landis, the head of the SEC, and with a fellow named O'Connor, who's the general counsel. They are defending the biggest constitutional litigation of the era at that point in time, the Public Utility Holding Company Act. It is 1935's healthcare statute. Jackson is Don Verrilli, not literally yet the Solicitor General, but the point litigator. They're still in the trial court, and then it goes up to the appellate courts. It's not won until the late 1930s that this major anti-monopolistic law, which is deeply, bitterly opposed by political enemies of the president and corporate interests and a lot of money and a lot of publicity and so forth, is constitutional. But that's a measure of the rising prominence and the sort of man for the biggest case identity that Robert Jackson has achieved. And then he's appointed Solicitor General of the United States, a nice office. This is a posed photo in 1938. This is the government's chief advocate before the Supreme Court. And he does that job for 2 years, arguing before this court. This is the post-1937 court. You see Justice Hugo Black on the far right. He's the first Roosevelt appointee. Chief Justice Hughes, Brandeis, McReynolds, Cardozo, Stone, etc. This is the court that was the 9 Old Men, the court of the 4 Horsemen, the anti-New Deal court that, of course, switched, changed, began to be much more deferential in its judging in the spring of 1937 in the teeth of the president's court package proposal. And by the end of that summer, Roosevelt has his first vacancy. That's the appointment of Black, and so forth. Jackson is arguing before this court for 2 years as SG and a little bit more as AG. About 38 to 40 cases. Some re-arguments make it a little tough to count. And he wins virtually all of them. It's a friendly court, but he is a spectacularly successful advocate before that court. This is a White House visit. Jackson is still the SG. And you see the justices arrayed to his right. That's Felix Frankfurter, Hugo Black, Harlan Stone, and so forth. This is the law Jackson. This is the court Jackson, not yet on the court, but the 10th Justice is a nickname for the Solicitor General, and in many ways it is a forecast of relevance and significance and trajectory. Elena Kagan is not the first, or even a small handful of SGs who have gone. Thurgood Marshall was an SG, Stanley Reed was an SG, Robert Jackson was an SG, William Howard Taft was an SG, people who end up serving on the Supreme Court. And so this Jackson is soon Justice Jackson. His interlude job is one that he didn't like very much, Attorney General of the United States. This is the AG's conference room, again a posed photo in 1940. It's his secretary's desk. Jackson had really no use for the big room. Yes, some staff meetings, but generally he used the small office. And in 1940, early in the year, at the time Jackson is appointed to that job, it really is an interlude to perhaps the big job. You see, FDR intended to retire after 2 terms. It's an American tradition. He built the library at Hyde Park. He'd signed a contract with a publisher. Jefferson at Monticello, FDR at Hyde Park in retirement. 30 years of hovering national presence. Think of Bill Clinton, perhaps. I think that's what FDR's authentic intention was. And then the question is, who's next? Well, it would have been a Donnybrook at the Democratic Convention in the summer of 1940. Urban machine Democrats, big city mayors, Frank Hague of Jersey City, Kelly of Chicago, etc. They would have been powerful forces against the New Dealers, who of course had the president and had their next generation. And it's pretty clear that in the early 1940 months, Jackson is their guy. Now, of course, world events intervene. Roosevelt plays coy for a while. Surrogates, including Jackson, begin a drumbeat for a 3rd term. Roosevelt indeed accepts a draft at that convention and runs and wins. And Jackson never, ever runs for political office. Instead, in 1941, he's appointed to this court. There he is on the far right. Sorry about my angle here. That's where the junior justice stands in the posed photos. You see Harlan Stone here, who is the Chief Justice. He was elevated simultaneously with Jackson's appointment. Jackson was the backfill appointment for the vacancy that had been Stone's seat. And also simultaneously, Senator James Burns of South Carolina was appointed. So in one fell swoop, in the summer of 1941, Franklin Roosevelt has a triple appointment, if you will, on the Supreme Court. And this court doesn't last long because Jimmy Burns hates it. It's a kind of indoor, cerebral, out-of-the-fray work that doesn't suit the temperament of a politician. He's a senator. When he's appointed, he's later a governor of South Carolina. And he's a manager. He's a very good manager. And so he begs to be relieved from duty on the Supreme Court, and Roosevelt grants it and pulls him off and appoints him to manage the domestic economy during the war. That's what Burns' job is. So now you see on the far right, Justice Wiley Rutledge was appointed by FDR to fill that Burns seat, and Jackson has moved up to Associate Justice number 7, seat number 8, if you will, on the Supreme Court. Now this is the 4-year period before Nuremberg. I wish to highlight 3 things in Jackson's judging at the Supreme Court during this time period. The first is a case that is much discussed these days, Wickard versus Filbert. This is an opinion that Jackson writes from the Supreme Court in 1942. It's a case that's argued in his first term. It's drafted, it's complicated, but in the end it's held over and re-argued in the fall of 42 and then decided. The court unanimously upholds Congress's power to enforce production caps on a wheat farmer from Ohio named Roscoe Philbrunn. The Supreme Court did switch the letters in his name. So the case is Wickard versus Filburn. Like many Supreme Court cases, that turns out not to be the litigant's actual name. And what the case was about was the scope of Congress's power under the Commerce Clause, the power to regulate commerce among the states. What Roscoe Philburn had done was violate the production quota on wheat in his own little Ohio farm by growing 200 extra bushels that he was using for seed, for animal feed, and for home baking and consumption. He was not taking this additional wheat to market. So he said, this isn't commerce, this isn't interstate, this is, like cutting my toenails in my own home. How does Congress have the power to reach this? And the Supreme Court said it's right there in the Constitution. And Jackson's opinion explains that interstate commerce is a large realm of activity that includes inactivity in any effect that, when aggregated across lots of small individual steps, of course, is substantial and market affecting. And by Filburn not buying his extra wheat in the market, what he's doing is withdrawing demand. His inactivity is causing demand to be less than it would be in the interstate market. That means less support for prices. That means less income for farmers. That means less effectiveness of the AAA as a depression relief statute for farmers. And Jackson writes this opinion, which is the sweepingest, broadest, unanimous Supreme Court articulation of what the framers put in the Constitution with our interstate commerce power. That, of course, was a big issue in the healthcare decision. In the end, it's one that the court somewhat sidesteps. They draw a distinction, we can come back to this in questions, between activity, which Congress's power reaches, and inactivity, which 5 justices, although not in one opinion, said the healthcare law is about. Being uninsured, they said, is inactivity. Well, as Justice Ruth Bader Ginsburg in 2 lines very effectively says, not buying wheat in the interstate market is also inactivity. We read Wickard versus Filburn. And of course she's right. And of course Chief Justice Roberts knows it. In his opinion, because he's a brilliant man and has, I think, intellectual honesty about this, he says, okay, economists understand that the distinction between activity and inactivity is false and artificial. Every act is the flip side of an inactivity event. And then he sort of sidesteps and said, the framers meant to limit the commerce power to activity, with no citations, no historical argument, etc. But that's Wickard versus Filburn. A big decision, a big landmark, a preserved landmark under the healthcare decision in the full range of activity, but not reaching what the court may in the future label as inactivity, should Congress ever pass such a law of that type. A second case that Jackson decides, Barrett versus West Virginia State Board of Education. Again, the court spells the name of the parties wrong. This isn't my selection principle, but it just happens that some of Jackson's biggest opinions are misspellings. The Barrett sisters didn't have an E on the end of their name, but they were Jehovah's Witnesses. They did have religious scruples against saluting the flag. They were expelled from school when they refused to salute the flag. Their parents thereby became criminals for not sending their children to the public school as the state law provided. And the Supreme Court just 3 years earlier had held that the government had the power, state governments had the power, to compel patriotism. And that was 1940, the Govitis case. This, goodness sakes, 1943, was now wartime. If the patriotism argument was strong on the eve of war, surely that was going to carry the day in 1943. Well, that triple play of appointments, plus some authentic reconsideration by Justices Black, Douglas, and Murphy, caused the court to change its mind in just 3 years, very directly, and to say that their previous decision was wrong, and that in fact there is a first dimension realm of conscience that entitles one to refuse to obey a compelled orthodoxy. The government may not prescribe what's orthodox in matters of faith, belief, religion. And so the court, Jackson writing for the court, strikes down the expulsion, the convictions, the flag salute of the state of West Virginia, a major liberty landmark in Jackson's pre-Nuremberg judging. The third piece of pre-Nuremberg judging I want to touch on is really sort of a trilogy. These are connected dots. The sequence is a case called Ex parte Quirin, a case called United States versus Hirabayashi, and a case called United States versus Korematsu. They aren't all about exactly the same thing, but you'll see the executive power thread that connects them. Ex parte Quirin was a habeas corpus action brought by a very brave Army lawyer who was representing captured Nazi saboteurs, challenging President Roosevelt's creation of a military commission system to adjudicate their guilt in Washington, D.C., in the summer of 1942, when, of course, the federal courts were wide open and doing regular business. By what constitutional power does the President of the United States do this? Have executive tribunals as an alternative to the regular criminal justice system? And Roosevelt's argument is, I'm the president, I can do this. The laws of war are one of the president's powers. And the Supreme Court, in an agonizing opinion, upholds that in the summer of 1942, unanimously, in a special summer session with a verdict rendered by the Supreme Court, and then after the convictions and the executions of 6 of the 8 saboteurs, opinion writing that follows, very awkward and uncomfortable. The Supreme Court says, in wartime, as a function of constitutional language and the international law of war as embodied in U.S. statutes and customs and so forth, the president may set up military commissions of the type that adjudicated the Quirin and companions case. Robert Jackson is the rookie justice. He is the Roosevelt inner circle advisor. He is the former Attorney General of the United States. He is not a writer, but behind the scenes, a very uncomfortable, agonizing, concurring reluctantly justice in the Quirin case. There's a great unpublished opinion, as there are in many Jackson cases, because his style of thinking was often to pull out a yellow pad, like I have in front of me, and begin to doodle. And sometimes in the form of an opinion. He'd read a brief and start to write what he thought his position would be. And then he'd start to read the other brief, he'd flip a page, and he'd start to write an opinion the other way. And then he'd flip another page, and he'd try to harmonize his thoughts and work it out and so forth. In the Quirin context, he got pretty far down the line of writing a limiting opinion about executive power, and then in the end, perhaps just deferring to his chief, because collegiality, comedy, and institutional function are values in the Supreme Court, he files it away. Now, 10 years later, that's going to come back. We'll get to that later. From Quirin, executive power, comes the Japanese-American cases, and that's what Hirabayashi and Korematsu are about. They, too, are sweeping executive acts of curfew declaration, of orders to leave the coastal areas of the West Coast, and then of internment. 1, 2, 3. And Congress backs up that executive order with federal criminal law, federal criminal consequences. So when Gordon Hirabayashi violates the curfew, he gets prosecuted, and thus his appeal to the Supreme Court. And when Fred Korematsu violates the exclusion order, he gets prosecuted, and thus his case to the Supreme Court. And the forgotten, and perhaps the most important of the cases, when Mitsuye Endo violates the internment order or challenges it, her case goes up to the Supreme Court too. Here are Jackson's votes and his roles in those cases. Hirabayashi, the curfew case in 1943, is upheld, again, unanimously by the Supreme Court, as executive power appropriate in the national security context, given the limited imposition of a curfew. Indoors, 8 p.m. to 6 a.m., not the worst thing a president could do to a person. The president may do so. Jackson, again, behind the scenes, is saying, wait a second, what's it based on? He's drafting. But in the end, he votes with Chief Justice Stone, whose opinion says, thus far and no further. This is only about the curfew. Well, already in the pipe, and a year later adjudicated as an exclusion case, is Fred Korematsu's case. Fred Korematsu didn't violate a curfew. He violated an order to report to a racetrack for processing as a Japanese American that was a way station on the way to the internment camp. Now, a curfew doesn't sound like a small deal to me, but being ordered to leave my home and report to a racetrack for exclusion from a coastal area is a bigger deal. And the Supreme Court, 6-3, one of its most notorious, infamous moments, upholds the exclusion order. The court's opinion says, see Hirabayashi. In national security crisis situations, the president has commander-in-chief, etc., authority to respond to potential threats based on military and intelligence judgments, and liberty must give way. Jackson and the two other dissenters say, hey, wait a minute. What about the thus far and no further part of Hirabayashi? This is exactly what I was agonizing about. In 41, 42, 43, in the Hirabayashi context, Jackson says, this is excessive. This is a liberty violation of the individual. This is beyond enumerated powers of the president. And, by the way, this is racist. This is based on ethnicity, heritage. Fred Korematsu didn't enlist in anything. He didn't choose anything. He was born of Japanese ancestry. The Equal Protection Clause prohibits that as to the states, and as a matter of due process, the national government can't do that kind of stuff, and nothing in executive power trumps that. Jackson's dissenting opinion in Korematsu is a landmark of great, great significance. Every justice to serve on the Supreme Court since World War II has in one place or another said, Hirabayashi, maybe Korematsu wrongly decided. But never has a court, in other words, 5 or more justices in an opinion, said Korematsu is bad law. The thing that says Korematsu is bad law is only 3 dissenting opinions: Owen Roberts, Frank Murphy, and Robert Jackson, in a losing argument in the fall of 1944. Now, one other thing is going on in this pre-Nuremberg period for Jackson and the Supreme Court. He's seeing how judging works, both in himself and in his colleagues. And he's finding it in himself an adjustment. The sort of advocate role, the executive branch temperament and reflex, etc., is where he came from, and he's wrestling with it. That's what those unpublished draft opinions are. He's learning to be a judge and to be independent. He later was asked by Tom Clark, Harry Truman's Attorney General, who was appointed to the court in 1949, how long does it take? And Jackson said, well, I asked Hughes the same question when I came on the court, and Hughes said about 2 years. Jackson told Clark, I think it took me about 4 years. And Clark, you can kind of do the math, but I think 3 years will turn out to be the right number for figuring out Clark's ability to transcend executive reflex and appointment loyalty and be an independent judge. But that's in himself. What Jackson's seeing in a number of his colleagues, to his great dismay, is that some of them aren't even trying. That some of them have an approach that is as partisan, as pre-committed, as reflexive as when they served in the executive branch. By 43, the Rutledge appointment, and 44, with the exception of Owen Roberts, this is an entirely Roosevelt-appointed court. Yes, Stone had first been appointed by Coolidge, but elevated by Roosevelt. But among these new dealers, Jackson, I'm summarizing a bit, sees that 2 or 3 or 4 of them continue to wear a New Deal hat in the Supreme Court. And he finds that deeply troubling and inappropriate. Indeed, in particular moments, he sees the most committed of them bullying the softer of them to come out this way and to do these things to help labor unions, to help the president, to help, etc., interests. And Jackson's quite disgusted by this. It impairs what were very close friendships. They continue to be friendships, but they're damaged friendships or lesser friendships. And it causes Jackson to think of quitting, of leaving the court. Now, a passing thought? No. Job interviews, salary negotiations, law firm retitling agreements all worked out for Jackson to leave the Supreme Court in 1943 because he loved law practice. He was figuring out how to be a judge, but to be part of a court that wasn't very judge-ish wasn't particularly satisfying to him. He was a little itchy. The President of the United States scenario had, of course, bloomed and disappeared. And so what Jackson was prepared to do was move to New York City and be something like John W. Davis for the lawyers among us, the sort of grand poobah of a major Manhattan law firm. Jackson, Simpson, Thatcher is what it would have been called. All worked out down to the draft letterhead. And then Jackson, I think with some serious advising from his very close friends here in Chautauqua County, reconsiders. He also discusses this with Franklin Roosevelt, and he pulls back and decides to stay put. Now that, of course, brings us into the spring of 1945 when the landscape again changes. Now Roosevelt's dead. Now Harry Truman is an unprepared, reluctant president stuck with this enormous job. Now World War II in Europe is almost won. And the big three, Roosevelt, Churchill, Stalin, have a commitment to prosecute the captured Nazis as war criminals, as international criminals. The executive branch, Truman ultimately, once he learns of the Roosevelt planning, delivers on that commitment and recruits Jackson off the Supreme Court to do that job. That's September of 1945, going over the London Agreement that Jackson had worked out. That's the signing of the London Agreement. That's the flight of Jackson and team to Nuremberg. That's the courthouse with cell block behind it that they found and used as their facility. That's the courtroom that they built and the trial that commenced in November of 1945 with Jackson as U.S. Chief Prosecutor. That's hard to see, but it's the defendants. That's the judges. That's Jackson cross-examining Hermann Goering in March of 1946. That's Jackson at the podium delivering one of his eloquent addresses. I think this is his closing argument in July of 1946. Jackson was AWOL from the Supreme Court for an entire year. He didn't ask Chief Justice Stone. He didn't consult any of his colleagues, even the ones he remained very close to, like Felix Frankfurter. He was recruited by Truman's emissary, Sam Rosenman, who was representing a consensus among Henry Stimson, the Secretary of War, and John J. McCloy, the Assistant Secretary of War. Amai Cutter was an underling in that group. Attorney General Francis Biddle. A lot of people were behind the selection of Jackson. Why? Big case, big lawyer. High-profile national moment, very high stature appointment. Commitment to the rule of law, person with, not literally, a quite convenient first name, Justice Jackson. And the court, not loving, young enough, ambitious enough, lawyer in Jackson responds to this call, which is, of course, the president's call too, and he goes and he does this. Now, while he is at Nuremberg, a bunch of things are happening at the Supreme Court. And I want to lay these as context and then turn to Jackson back at the court post-Nuremberg. One is a decision. In January of 1946, the court decides a case, United States versus Yamashita pronunciation, which is a challenge by Japanese General Yamashita to the U.S. military prosecution as a war criminal that he's being subjected to in Allied-occupied, U.S.-occupied Japan. That case comes to the Supreme Court, and after much agonizing, the court upholds the validity of the process. It doesn't say lack of jurisdiction. It upholds the validity of the process. And it's a 6-2 decision. The two dissenters happen to be Black and Douglas, the people Jackson is least close to on the Supreme Court. Justice Wiley Rutledge is one of the six, but heartbroken about it and devastated and really doesn't want to make that mistake again because he's uncomfortable about the procedures that General MacArthur and this procedure in Japan has set up for Yamashita. But that decision happens while Jackson is doing something that is at least arguably similar in Nuremberg. And what does that mean? Well, theoretically, and perhaps literally, it means at least some Supreme Court interest in reviewing, adjudicating, constitutionally scrutinizing Jackson's job at Nuremberg. Now, he's still mid-trial. Nobody's been convicted, so nobody's going to be petitioning, but you can sort of see it coming. And for Jackson, who's still friends, but not best friends with various people, because he doesn't think they play fair, he sees this as a threat that's coming. He thinks it's based in perhaps legal argument, but much more in personal envy and personal pique, and something that he regards as an illegitimate style of behaving in the judicial realm. That's one thing that's coming. A second thing that happens just 3 months later, and perhaps connected, is that the Chief Justice, Harlan Stone, drops dead on the bench of the U.S. Supreme Court. Stone had been elevated by Roosevelt in 41. He was 68 years old at the time. Chief is a hard job. Stone was a heavy guy, and it was a sedentary time, and that was lights out in April of 1946. It's a job that if Franklin Roosevelt had had another chance to fill, likely would have gone to Robert Jackson. Now, Harry Truman is, of course, the president. It's his job to fill, but among the sitting justices, who's first among equals? Well, by all lights, the one who he's plucked for a special assignment. And so Harry Truman, indeed, reflexively, automatically, and publicly, well, at least on paper in lots of private circumstances, decides to elevate Jackson. Indeed, not to elevate Jackson would be something of, in modern words, a deep dissing of Jackson at Nuremberg by Truman, who sent him there. You're good enough for the world, but you're not the person I'd pick for this vacancy I unexpectedly had. And then what happens is a great Washington, behind the scenes, knives out, ugly, ugly story. And this also may resonate with contemporary events. Jackson is thousands of miles away in a time of very primitive communication, and he's not flying home. He's in the middle of this trial. And anti-Jackson forces, knives out, run this incredibly aggressive campaign, publicly, privately, media, etc., and they change Harry Truman's mind. They persuade Harry Truman that Robert Jackson ain't as great as you think. That indeed, if the Supreme Court is a fractured and uncomfortable place, guess whose fault it is? Robert Jackson is the problem. He's the bad guy. Truman, not wanting to prolong this, it takes him almost 2 months, and not knowing how to sort of parse this, decides, I'm not elevating any of you. I'm going to take my Secretary of Treasury, Fred Vinson, a former circuit judge, and make him the Chief Justice of the United States. And that happens in June of 1946. Stone dies in April, Vinson appointed in June. Jackson's still in Nuremberg. Now, Jackson has, of course, gotten plenty of wind of all this conniving and attacking that's going on. And Jackson then does what I want to highlight as a third Supreme Court-related thing while still at Nuremberg. He publicly defends himself in an unprecedented public telegram from him to the chairs of the Senate and House Judiciary Committees, saying, let me tell you about the Supreme Court. If there's bad behavior in the Supreme Court, let me tell you who it is. It's not me. It's the justices pushing other justices to hand down decisions to help labor unions during ongoing negotiations. It's the justices who in conference stand up and threaten to hit each other in the jaw. It's the justices who decline to recuse themselves from cases being argued by their former law partners with whom they continue to have ongoing financial relationships. In other words, it's Black, Douglas, and to a lesser extent Murphy and Rutledge as part of their cohort. And I just thought you should know. I didn't say this before the president acted because I didn't want to be seen as a special pleader. Fred Vinson is a great man. He'll be a great chief. Thank you for doing that for the country, President Truman. But I've been attacked, and I thought I should defend myself. Now, to give you a counterpart, imagine if John Roberts last week from Malta, where he is teaching a summer course, had walked to a microphone or done a blog post or sent a cable or whatever, blasting his colleagues for saying dirty stuff about him. that would be the counterpart event. I'm glad that Chief Justice Roberts didn't do that. I think it's regrettable that Justice Jackson did it, but there is something sort of noble and stand up for yourself-ish about what Jackson did in 1946. And all of that is part of the context when he returns to the court that fall. Now, what I wish to do in the last segment here is touch on 10 points, 10 cases, if you will, that are part of Jackson's post-Nuremberg service on the Supreme Court. This is the day or two after he has returned and the court has resumed its term in the fall of 1946. You see on the left Hugo Black and Bill Douglas, the clerk of the court, I can't quite see who that is, maybe Harold Burton, and Jackson, yucking it up. There's a popular shallow misunderstanding that this court evermore after Jackson's public attack in June 1946 was a nest of hornets, a polarized place, riven by hatreds, no more friendships. Totally, totally wrong. There were camps, there was sniping behind the scenes, there was some mutual low regard, but there were underneath all of that, and over time, evolving through all of that, continuing collegial, functional relationships, indeed friendships. For example, Hugo Black, portrayed as a great Jackson antagonist and somebody who, Jackson loathed and who loathed Jackson from 46 forevermore, becomes again, by 1951, a close, functional colleague and friend of Robert Jackson. Justice Douglas, on the other hand, not quite so much. But I wanted to sort of give you this visual to show you that oversimplifying is oversimplifying. This is worth noting because this is going on while Jackson is back in the Supreme Court. This is Telford Taylor, one of Jackson's deputies in the International Nuremberg trial, who stays and is the chief prosecutor in the 12 subsequent cases that are U.S.-only cases in Nuremberg. So, war crimes prosecution, Nuremberg is a continuing international event and a legal event while Jackson is back on the Supreme Court. And this is the Vinson Court. You see him in the middle. You see Jackson, Tom Clark, Sherman Minton. Those are Truman's 1949 appointees. This is the court that I'm now talking about. Case number 1. Erhard Milch versus United States. The name may ring a bell. He had been Hermann Goering's number 2 in the Luftwaffe. He had testified as a defense witness in the International Nuremberg trial. He had been cross-examined by Robert Jackson, who sort of carved him up very effectively in that trial. And in one of the subsequent proceedings, he was prosecuted by Taylor and convicted. He petitions the U.S. Supreme Court for writ of habeas corpus to adjudicate the illegality of this U.S. tribunal, which has judged him at Nuremberg. The court declines to grant leave to Milch to file this petition, 4-4. This is in the fall of 1947. Where's the ninth justice? That's Robert Jackson, recused, for obvious reasons, from such matters. The 4 tend to be the camp that I've identified, and on the other side, Vincent, Reed, Frankfurter, and Robbins. This case is the start of a flow that, in the end, is about 30 cases of war criminals, both European theater and Pacific theater, petitioning the U.S. Supreme Court to review the legality of the tribunal processes, U.S. and international, that have adjudicated their guilt. The next case I want to touch on is called Hirota. It's a Japanese case. Hirota was a senior officer in the Imperial Japanese military. He was prosecuted before the International Tribunal for the Far East. And he petitions, as Milch had, as lots of others had, for the Supreme Court to review. And the court was again divided 4-4. What's unique about Hirota's case, however, is that it's from the Pacific theater. Really, for the first time since Yamashita, it's a non-Nazi case asking the Supreme Court to take a look at this. And the court needs 5 votes to review a habeas petition. It's not granting cert. It's reviewing an original jurisdiction habeas petition. And it's frozen 4-4. So the 5th vote in Hirota's behalf in December of 1948 is cast by Robert H. Jackson. Now, what's that about? Well, he says, in an opinion that sort of puts it all out on the table, I have an obvious interest in the prosecution of war criminals. But I have an obvious interest in the rule of law, too. And the paralysis of a 4-4 court is an undesirable legal situation. So in this case, I will vote to grant the review, to give Hirota his hearing before Supreme Court, from which I will recuse myself. I won't participate in the merits of this, but I will let the court actually look at the legality of this tribunal. Now, what Jackson's doing is an incredibly gutsy move, because the IMTFE, the Far East Tribunal, is modeled very directly on the IMT, the Nuremberg Tribunal. And in a sense, he's putting in the hands of some people who still have knives in their hands for him. Not just Japan, but Germany. What happens in Hirota's case is, after that hearing, the court decides 6-1 and 1 that it has no jurisdiction. That this is an entirely international proceeding governed by international treaty, agreement, and international law, and not a creation of the U.S. government, and thus not within any jurisdiction of the U.S. Supreme Court. The seventh vote, 6 are in the majority, the seventh vote is Justice Douglas, one of the Yamashita dissenters, one of the Jackson antagonists, if you will, agonizing, again, quite publicly and commendably, but saying in the end, overseas is overseas. The last vote, I said it was 6-1 to 1, was Wiley Rutledge. This is December of 1948. This is 2 years after Yamashita, which had broken Rutledge's heart, where he thought he'd done the wrong thing. And he's drafting and drafting, but never quite deciding where he comes out in this Hirota case. And he never does. And he dies in September of 1949, still having promised, but never actually having filed an opinion in the Hirota case, which I think shows some of the personal stakes and difficulty of judging. And Rutledge is a great figure, perhaps overly agonizing about the deciding process, but really trying to judge this as a matter of conscience. The next case, Terminello versus United States. Father Terminello was a priest of sorts, but a virulent racist speaker, anti-Semitic, anti-Negro, etc., etc. Speaking in a town meeting in Chicago, attracting a rabid group of supporters inside the hall and a rabid group of critics outside the hall. And of course, then they start meeting up, and punches are thrown, and bottles are thrown, and the cops come in, and arrests are made, including Terminello, for breach of the peace. This case comes to the Supreme Court. Terminello says First Amendment, freedom of speech, and the court vindicates him. He wins that case. My focus is Robert Jackson's dissent, famous for a small phrase, suicide pact. He says, unless we're careful, the majority could turn the Constitution into a suicide pact. But what Jackson's argument amounts to in substance is, I've seen rabid mobs, Nazi Germany, 1933, etc., and what they can evolve into. And it is not the speech or the message, but the conduct that is involved in a case like Terminello's, the actual physical battle. The First Amendment is not an absolute. The First Amendment is a decision to protect the individual broadly, expansively, structurally, but not without limit. And when bottles are flying and blood is flowing and police are breaking up riots, that line has been crossed. Now that's very informed by his deep study of Nazi Germany and mob behavior as a Nuremberg prosecutor. Case number 4, very briefly, United States versus Eugene Dennis and co-defendants. Eugene Dennis was a figure in the leadership of the American Communist Party, and it was prosecuted in the late 1940s for conspiracy to overthrow the government of the United States. This is Gus Hall and Eugene Dennis and Ben Davis and etc. Huge year-long trial before Judge Harold Medina in New York, a circus trial. And this case results in convictions. The convictions are affirmed by the Second Circuit. It comes to the Supreme Court, and they are affirmed uncomfortably by the Supreme Court. What Robert Jackson writes in his concurring opinion is a meditation on totalitarianism. That some ideas are different order from all others. And what he's really writing about is not just communism or Stalin or Leninism or Marx. What he's really writing is about Hitler, about totalitarianism, about having seen what the abolition of liberty and freedom and totalitarian power aspires to be. And just like Terminello had an outer boundary that in Jackson's view had been crossed, Dennis and his co-defendants had an outer limit that Jackson and his majority colleagues believed had been crossed. I'll do a sentence on Eisentrager. The next case is called Eisentrager versus United States. And this is another merits case. It is a military tribunal. It's a complicated both Pacific and Germany situation. And Jackson writes for a court that prosecution and detention and behavior that's all entirely offshore is beyond the jurisdiction of the United States courts. Thus, Eisentrager, a Nazi war criminal being held by the U.S. in Landsberg prison in Germany, didn't commit crime, wasn't prosecuted, didn't touch U.S. soil, thus didn't touch jurisdiction of U.S. courts. That's an opinion, again, it's probably fair to call it Nuremberg protective, that has a majority of the court with Jackson writing. It's an opinion that in 2002 is the linchpin of the legal strategy that John Yoo and colleagues put together to set up Guantanamo. That 90 miles offshore is offshore. Close enough to be convenient, incredibly powerful total lease-based control by the United States, but no foot on U.S. soil, thus no review in U.S. courts. And what the Supreme Court did in the Guantanamo war on terror cases in subsequent years was distinguish Eisentrager. Eisentrager as a full due process-based proceeding that he had been subjected to, as opposed to what Guantanamo was. That's a Jackson. Number 6, Youngstown Sheet and Tube versus Sawyer. This is the return of Quirin, of Korematsu, of Hirabayashi, of Wiley Rutledge's discomfort with the Yamashita decision, although he's not around to be part of it. Harry Truman has seized the steel mills in the Korean War because labor unrest was going to shut them down and cause steel production to cease, which would be military devastating event. And the Supreme Court takes this on a hurry-up basis, and the Supreme Court 6-3 holds that the president doesn't have this kind of power, not as commander-in-chief, not in terms of taking care that the laws be faithfully executed, not as some inherent matter, not as national security, that Congress has to confer seizure power. And Congress in this case had. Indeed, Congress in this case, through the enactment of Taft-Hartley without a seizure power, had declined to give the president this power. The 5th and 6th votes are the most interesting parts, although Jackson writes the best opinion and the one that's the precedent in Youngstown Sheet 2. The 5th vote is Tom Clark's. How long does it take you to become a Supreme Court Justice, Bob? He asked Jackson in 1949. Well, I asked Hughes, he said 2, I think 4. This is 3 years on the court. Tom Clark, Harry Truman's former Attorney General, casts the decisive 5th vote against Harry Truman in this case. Because personal affection, former service, and legal representation as Attorney General doesn't mean you own my independent constitutional interpretation forever. And it's just not there. This was a permanent breach in the Truman-Clark relationship. But I think with some assistance from Jackson as a mentor to Tom Clark, a very proud moment in constitutional law. Case number 7, Mizei, Shaughnessy versus United States ex-rel Mizei, M-E-Z-E-I. Mr. Mizei, a resident of Buffalo, had immigration status and complex presence in the United States that he screwed up by leaving the country for personal reasons briefly. And on his way back in, was detected and detained on Ellis Island, and was a sort of prisoner in limbo on Ellis Island, seeking Supreme Court habeas review. The court, in that case, upholds the president's detention authority. It's a complex immigration decision. But 4 justices dissent. Black and Douglas in a broad, sweeping, liberty-focused dissent, and Frankfurter and Jackson, not joining their opinion, but voting with them, with Jackson writing separately, in an individual prisoner-focused liberty interest dissent. What I love about that one is that Jackson, maybe with ego, but with relevance, cites directly his cross-examination of Hermann Goering to talk about preventive detention and perpetual imprisonment as a tool used by the Nazis. And Jackson distinguishes rule of law systems like ours from that kind of behavior. A 9th case, United States versus Carragher. I mention this because it's relevant again. It's always been relevant. Article 1 includes a congressional taxing power. Congress has the power to tax. And in the Carragher case, the Supreme Court abandons the conceptual line drawing that had been part of its law earlier in the 20th century to try and define limits on congressional power. Basically, if Congress is raising money in a way that's not extremely disproportionate, that has penalty or regulatory effects but still generates revenue, Congress can do it, and it's not for the court to say no. You see the Carragher case cited in Chief Justice Roberts' tax power section of the opinion, and Jackson's concurring opinion in Carragher, much like his Wickard v. Filburn opinion regarding the Commerce Clause, lays that all out. I want to finish with a 10th area. That's a couple of cases. This shows you some levity among the justices of the Vincent Court. And this, well, does anybody recognize that place? I don't know if there's much California in the room. That's the tower of the Hoover Institution at Stanford University on the campus. And that's Jackson dedicating a new building at Stanford in the summer of 1950. I focus on Stanford because I want to give you a couple of words about a man named Charles Fairman, who is a huge figure in American constitutional history and constitutional law and Nuremberg. Charles Fairman was a political science professor at Stanford, who by co-appointment also taught in Stanford Law School. In the war years, Fairman became Colonel Fairman and served in the JAG Corps in Washington, D.C. And a brilliant legal thinker, became a sort of rule of law, war crimes specialist. Thus, when Nuremberg started, he was pulled over to Germany and became the senior legal advisor to the commander of the theater, Edward Betz. And there meets Jackson, and works extremely closely with Jackson and Lucius Clay and his chief legal advisor, Charles Fay, and others on the prosecution of war criminals, the international trial, and the subsequent proceedings. Indeed, Charles Fairman, history doesn't give him credit yet for this, is the father, the intellectual father of the subsequent proceedings that Telford Taylor prosecutes. Now, Charles Fairman comes back from Germany too, and resumes being a professor at Stanford, and is a Jackson friend, acquaintance, becoming a friend, and is teaching people like an undergraduate named William Rehnquist, who served in the Army Air Corps and ends up at Stanford in the late 1940s and so forth. This is a telegram that Bob Jackson sent to Charles Fairman in 1950. It's very short, it's hard to read. It says, "Letter received, keep praying." What was going on at the Supreme Court in the spring of 1950? Yes, grace. Always has been going on at the Supreme Court, of course. We talked about Korematsu, Dred Scott, etc. This is our constitutional firmament's most defining, awful, unsteady piece of ground, if you will. Our first Constitution and our second Constitution blew this. Our third Constitution after the Civil War began to address this, and the Supreme Court in the late 1940s and in the spring of 1950 is beginning to deliver on this. And Robert Jackson, a judge, a lawyer, a man of honest legal argument, knows that there's no legitimate claim that the framers of the 14th Amendment intended to rule out segregation. They'd segregated the D.C. schools simultaneously. They had lots of things that indicated their superiority and inferiority views of whites and African Americans. And now Thurgood Marshall and the NAACP are challenging, in a series of cases, segregation systems, restricted covenants, graduate school, law school, and you know where we're going. And Charles Fairman, corresponding with Robert Jackson, Professor Fairman and Justice Jackson, have this exchange. And this is Fairman's letter. I'll go to the next page because it's the line Jackson's referring to. Fairman's going on, and this is page 11, I think, of a very long letter, where he's concluding, and he said, I beg leave to pray again on it, and further thought, and I may think of something better to pray for. He's gone through a long legal argument about why the 14th Amendment prohibits racial segregation, but says, I'm thinking about this too. I'm working on this legal argument. I'm just a professor. I'll continue to pray on it. And Robert Jackson responded to that with a telegram that said, keep praying. And when Robert Jackson works out what the Supreme Court works out, in this spring of 1950, Sweatt versus Painter, McLaurin versus Oklahoma, Henderson versus ICC, is really the invalidation of race-based segregation. It takes a new chief and a few more years and the ultimate litigation of numbers in elementary and secondary schools for the Brown case to come to the Supreme Court. And what Judge Jackson and the other justices following the leadership of Earl Warren come back to is literally the language of the Constitution. Sometimes the Constitution doesn't need to spell out much beyond a clear, simple, declarative conferral of power or protection, what it's about. Equal protection of the laws means equal protection of the laws. Power to regulate interstate commerce, power to tax, I would say, mean that and not much more. And what Jackson in his judging does, of course, in this race area, and what the correspondence with Fairman illuminates, is we have seen what the alternative is about. We in Germany, we in Nuremberg, we prosecuting Hitler and henchmen know where racist ideology leads. And of course, Jackson had worked that out for himself in Korematsu in 1943 and 1944. And in the Brown case, the last major decision of Robert Jackson's life, May of 1954, he and a unanimous court come back to literally the Constitution, which sometimes is a great and powerful fact. Thank you very much.